May it please the court. I'm Mark Stopa, counsel for the appellants. I would request 5 minutes for rebuttal.
Sure.
Thank you.
Mr. Stopa, this issue, this is what, the fifth or sixth or seventh argument that you both had?
I think it's number 7 for me
Number
on this
7?
559-715.
All right.
And, Judge, I was actually going to start with that. It's funny you say that, because in a lot of the prior oral arguments, including a couple with you, I think this is my third with
Yes,
you, the issue has come up of, is this the right case, correct case to write an opinion on? There were preservation issues, and some of the cases turned on factual disputes potentially. To me, this is the perfect fact pattern to write an opinion on. It's de novo review. Everything was preserved. They're not even arguing preservation at all. This isn't a case that turns on the facts at all, because the other side had no notice of assignment of the debt as contemplated by the statute, and they acknowledge that in their own testimony. You purely have the legal issue of whether the statute applies in the mortgage foreclosure context.
One of the issues I think is raised in the briefs is there anything that indicates that this is anything other than a residential foreclosure? Because if it's a consumer debt, I'm assuming it has to be a residence. It can't be commercial property. It can't be rental property.
Sure.
Do we know that for sure?
I think it's clear that it's a residence, but I would also submit, and I talked about this in the brief, to the extent that the record was unclear, it's the plaintiff's burden of proof to prove compliance with a condition precedent, and if the record were silent on that issue, I think it's pretty clear it was a residence. But if the record had been silent on that issue, they didn't meet their burden. I cite the Boltby case out of the 5th DCA that's really clear on that, and the standard jury instruction out of the Florida Supreme Court for a condition precedent puts the burden of proof on plaintiffs. So, to me, that doesn't help.
There are loan
them.
documents suggest that it's supposed to be a structure that is going to be used as a residence.
Correct.
But I think that's all I could see.
I don't think there was anything beyond that.
Well, the test under the federal law is what is the intended purpose of the loan at its inception. So even if let down the road they decided to rent this out, it's still, I think, if it's...
Totally agree with that. And to me, the way this case unfolded, it would have been the plaintiff's burden at trial to put on some evidence that this loan was not taken out for personal, family, or household purposes. That's how the FCCPA defines debt, as this was for a personal, family, or household purposes.
So the question is, does it apply? So the question before us is, does it apply to an attempt to foreclose on the security for the consumer debt, assuming this meets the definition of a consumer, versus a direct suit on the debt itself?
I would rephrase your question slightly. I think the first question is a mortgage foreclosure suit that is precipitated by a letter demanding money, and that includes a request for deficiency in the complaint, is that an action to collect debt? Because that is the fact pattern that you have before, Your Honors.
That's different. If that's accurate, that's different than what I've seen in some of the 11th Circuit cases.
Right.
We're not just, am I accurate? We're just not trying to foreclose our security interest. We've made a demand for money, and there's a request in the complaint
For money beyond the security.
Right, and I do think there are different permutations of the facts in some of these cases. For instance, in the Burster case of the 11th Circuit, that was only a letter demanding money, a paragraph 22 letter. And there the 11th Circuit said just the letter demanding money is debt collection. Well, here you clearly have the paragraph 22 letter. They introduced it into evidence at trial, right?
Because it's always supposed to be a paragraph 22.
Exactly. Mm-hmm. Well, on your standard Fannie Mae mortgage,
right.
Sure. So to me, that clearly makes this an action to collect debt under the 11th Circuit precedent. And to me, the other cases, the 3rd Circuit, 4th Circuit, 6th Circuit, those are really powerful decisions. For instance, the Glazer decision, 6th Circuit Federal 2013, filing any type of mortgage foreclosure action, even one not seeking a money judgment on the unpaid debt, is debt collection under the Act.
Well, even if this debt collection, as I read the Florida statute, there's no private cause of action. You agree with that? So
totally.
I'm struggling with the notion, how does that inform our thinking about how I can challenge it as a failure to comply with a condition precedent?
Well, to me, that shows that it has to be a condition precedent, right? Because The question becomes, we all know that you have to give meaning and effect to all provisions of a statute, particularly in the consumer protection context. So where you can't sue as a consumer for a violation of 559715, the question becomes, how does a court enforce the plain language of the statute requiring the notice be given 30 days before any action to collect debt?
Or the statutory scheme provides for a regulatory enforcement of the provision. I mean, you may think it's inadequate, but it does provide for regulatory enforcement.
I respectfully cannot imagine a decision coming out of this court in the consumer protection context that says that the remedy is, well, go hope that the state attorney files for an injunction. If that's the remedy that you're discussing, that's the only one that they even argue in the statutes. I just can't imagine that.
So, so every mortgagor becomes a private attorney general.
I believe that, and I've cited several cases on this, that the language of the statute, the way that it's worded, consistent with longstanding precedent, operates as a mandatory condition precedent. I cite the U.S. Supreme Court in Hallstrom. I cite a Florida Supreme Court decision. I just did a supplemental authority on that yesterday. I just recently found it. A 2nd District decision and a 4th DCA in-bank decision with no dissents. All of those cases hold that where you have a statute that requires a notice to be given before an action is taken, even where that statute doesn't have the term condition precedent in it, that notice is a mandatory condition precedent as a matter of law. The way I argue this, and I do it all the time, I basically challenge everyone who comes across this to present an opposing case, right? Here we have Ackerman today. If there were an opposing case, you know that they would have it here. There is no case in any context, anywhere, ever, that interprets a statute that requires a notice to be given before an action taken as anything other than a condition precedent.
And it's interesting, Mr. Stoppa, because bringing these issues all the time, you have a number of circuit judges who've gone your way. You've got a number who've gone the other way. You've got Middle District of Florida going one way. You've got the Southern District going a different way. So there's a lot of, obviously this is a very hot issue for debate. So take a moment and say, why is this an action to collect a debt?
Because the way that the FCCPA defines an action to collect, defines debt, and the way that the federal cases construe that, and the way that this court in Gann interprets that, it just has to be. For instance, Gann, which follows Reese, explains how, why would an action to collect money be an action to collect debt, but if you're foreclosing a security interest that secures that money, not be an action to collect debt? That would create a loophole in the FCCPA. That wouldn't make sense. That's what the 11th Circuit said in Reese. And this court followed that decision in Gann. Judge Northcott, you were part of that Gann decision in saying, we're not going to do that. We're going to follow those 11th Circuit decisions. Now, the trial court decisions, and there certainly are trial court decisions that have gone against me on this issue, I submit, just as Judge Silberman noted it a couple weeks ago at an oral argument, those decisions really don't have any analysis in them, right? They just kind of have one sentence of, this isn't a condition precedent, like Summerlin, that my opponent cites a supplemental authority. One sentence, this is not a condition precedent. They cite 2 circuit court decisions as authority. That's all they cite. I was counsel in both those cases. Both those decisions predate this court's controlling decision in Gann, and there was no explanation about the cases that I give, like Hallstrom or Neat or Freeney, that have a statute that requires a notice before suit is filed as anything other than a condition precedent. Trent out of the Middle District of Florida, to me, that's one trial judge's decision, right? One. Summerlin is one trial judge decision. I have 47 trial judge decisions, and look at the appellate panels, right? The appellate panels, I feel like those all go in my favor. Not just this court's decision in Gann, but you've got the 3rd Circuit, the 4th Circuit, the 6th Circuit, the 10th Circuit, and the 11th Circuit. My opponent can't cite to any appellate panels that go their way on this issue at all. And these appellate panels, unlike the trial court decisions, which typically have the trial court judges that go against me on this, they really don't have any analysis for the 1 or 2 lines. If you read these appellate panels I've cited, these are pages and pages of analysis. For instance, in Glazer, we hold that mortgage foreclosure is debt collection under the Act, and then the decision is pages long explaining why that is with analysis. The 4th Circuit did the same thing in Wilson. These are the decisions that go my way have long analysis. The only appellate...
Is this a strict liability situation? I guess my question is, what's the harm to your client of not having gotten the notice of assignment?
Well, to me, the best way to answer that question, and I'll try to answer it more directly, is that harm is not a part of the analysis. And I cite a Florida Supreme Court decision in my amended reply brief that says if the legislature, for a statutory condition precedent, if the legislature wanted prejudice to be part of the analysis, they would have made prejudice a factor in the statute. Where the legislature doesn't make prejudice a part of the analysis for a statutory condition precedent, courts can't do so. That was the Strescon case out of the Florida Supreme Court.
Is there anything that the notice of assignment would have given you that was not provided by the paragraph 22 letter prior to the institution of foreclosure proceedings?
Who the plaintiff is. The paragraph 22 letter gave no mention of the plaintiff at all, no mention of the entity that was filing the suit at all. No mention whatsoever. And so I submit that your question goes to, well, what is the purpose or what is the intent of the statute, which to me, you don't get to that question as a matter of statutory construction when you have a statute that is clear and unambiguous on its face. It requires a notice to be given before an action is taken. Prejudice is not a factor in the analysis, and neither is equity.
So let me ask you a question, Mr. Upper. Let's just assume we go your way, we agree with you. What's the result? We make a finding that, yes, it should have been a condition precedent. What effect does that have then? This case goes back?
Oh, no, I think it's very clear, Judge, and I think it was implicitly admitted in their briefs that the remedy has to be reverse and remand for an involuntary dismissal without prejudice. That's the result in the paragraph 22 context, like the 4th DCA has held twice. In the Holt decision, for instance, if the paragraph 22 letter isn't given, that's a condition precedent, right? The remedy is reverse and remand for an involuntary dismissal. There's no new trial. That's the same thing you have when a plaintiff doesn't prove standing. There's legions of cases on that. I mean, I feel like I spelled those out very clearly in my initial brief, and then my opponent...
They can refile.
Sure, of course,
They could refile
right.
within the statute.
Right, dismiss
of
without
limitation.
prejudice, right. There's no new trial, they can dismiss without prejudice. So you reverse and remand for an involuntary dismissal without prejudice. I don't think they even argued otherwise. I know they didn't argue otherwise in their answer brief, so I don't think there's any dispute about that. When you don't comply with condition precedent, it should be dismissed without prejudice. Now, equity is not part of the analysis here either, and my opponent talked about this, and having done this so many times now, I sort of want to talk about that because I kind of have the impression, I almost feel like I've argued this in bank at this point.
Well, it's really not an issue, but it's really not an issue because your argument is it's a legal one. So we
Sure.
can't, and the legal.
Purely a matter of contract and statute.
Exactly,
Thank you.
and nothing to do with equity. And I know a lot of people would say, well, but look at your clients. That's aside. You have to set that aside.
Thank you. Thank you.
You're
Because,
a poor one-legged guy who can't see, no, you don't even have to do that, do you?
yeah, to me, it's very clear that equity is not part of the analysis. My opponents argued in their brief that it should be. You can't go down that road. This is a legal issue. Either the notice was given or it's not. You conclude it applies or it doesn't. I'm glad to hear that your honors are agreeing with that. I also submit, as you contemplate that issue and perhaps discuss it with others, because I sort of have the impression that's going on, that case management concerns not drive the train either, right? Because I know there's a lot of these cases, and some of the judges have even mentioned that to me in some of these decisions. I would submit that what's more important is how are these decisions going to be viewed in 10 or 20 years by law students? Are they going to see courts that were following the law even if it went against any case management concerns that might exist, or were we bending the law just a little bit in order to try to appease case management concerns? I submit that I really appreciate the comments about equity not being a factor, and we should just be following the law. I think it's really clear when you look to the decisions that I'm citing in these federal appellate panels. The appellate panels are basically all going my way. My opponent cites Donovan. That's really the only appellate panel that they cite. And that, to me, is so clearly distinguishable. That's an 11th Circuit decision, but that emanated from Alabama, a non-judicial foreclosure state. And the holding of that case was that the mere posting of a notice of foreclosure sale in a non-judicial foreclosure state was not debt collection.
That case did not involve an effort to collect money.
Exactly.
Focusing on the security interest.
Exactly, and there's a 10th Circuit decision that I cite in my reply brief called Maynard, which makes that distinction. They distinguish between judicial foreclosure cases, which are all about money, and non-judicial foreclosure cases like Donovan, which are just non-judicial posting a notice. Literally, it's just posting a notice in a non-judicial foreclosure.
There's a difference because in the situation where you are as part of your where foreclosed, you're seeking potentially a deficiency judgment, but your entitlement to that does not arise until your efforts to deal with the security interest or foreclosed sale issue of title.
I don't
Does
think
that make a difference?
I don't think that the fact that the request for a deficiency emanates after the judgment of foreclosure is entered makes a difference. Under the Southern District of Florida cases that I string cited for that, the fact that they requested the deficiency in the complaint itself made the initial lawsuit an action to collect debt. I don't think whether they even decide to pursue the deficiency or whether they just never pursue it makes any difference.
It's already done.
Right, it's already done. It was already done at the very beginning. When they sent that paragraph 22 letter demanding money, when they filed that foreclosure lawsuit saying that a certain amount of money was unpaid, and in that foreclosure complaint, they asked the court for a deficiency in the wherefore clause of the complaint, that locks it in. That makes it an action to collect debt at that point forward.
Okay,
And
Mr. Stope, you are at 15 minutes. You want to save some time? You probably ought to.
thank you, Your Honors.
May it please the court, good morning, or I guess we're just into the afternoon. Good afternoon. My name is Adam Schwartz with Ackerman on behalf of the appellee, and I thank you for the opportunity to discuss the issues presented to the court today, which I litigate all across the state of Florida, just like Mr. Stopa does. And today, the court should affirm the final judgment of foreclosure because the narrow, sacrosanct act of filing a civil complaint for the equitable foreclosure of a security interest in real property is not an action to collect a debt.
But your lawsuit is something later. You start off with your demand for payment, correct?
Yes, Your Honor, and I think
that's
that
a precursor of the lawsuit.
And that is that paragraph 22, you have accelerated the debt too, so you're demanding the whole thing, are you not?
well, I think that acceleration is part of the remedy under the contract for foreclosure, but I think that that brings up a really good point because you have, and the case law supports this, you have two different things going on. And when I said the narrow sacrosanct act of filing a foreclosure complaint is different than the breach letter. There's no dispute that there's a debt, there's a promissory note. There's no dispute that cases have held that if you do things outside the context of filing a mortgage foreclosure complaint, you send a debt collection letter, you send the breach letter, those things may be actions to collect the debt. What we're talking right here is the narrow sacrosanct act of filing a mortgage foreclosure complaint. And I think
But
that
that's
that's what
still-
separates it.
I know, but if you could think it through, by virtue of filing the mortgage foreclosure complaint, what is your end result? Your end result is you're trying to collect that debt.
No, I think you're trying to enforce a security interest, Your Honor, respectfully.
Well, but if you.
But one
but
step
if you
further.
also,
Yeah.
Mr. Stubb is suggesting that in your prayer for relief requesting a deficiency.
And I have a good point to that, Your Honor. If you look at Form 1.94 floor, the model foreclosure complaint that's put out by the Florida Supreme Court, it includes a prayer for deficiency.
Right, but there's no law that says you have to include that prayer. That's your option. There's no law that says you have to use the form.
I understand that, and I would agree that there's no requirement, but the form does set that forth. And 702.06 Florida statutes gives the court authority to issue the deficiency whether there's a reservation or a prayer for it or not.
Okay.
But
And maybe though, even if you don't seek it in your complaint, you haven't started a debt collection yet until you ask for it or a tenant at the end of the case. But
I think that if we're going to look to the pleadings of the issue, I think that the better look, when you look into a pleading, is there's a breach of note, I want a money judgment, or is there an equitable foreclosure? And we have firms putting all sorts of different languages in the prayer for relief, but is the relief you're requesting a foreclosure relief? And it is in this case because they asked.
Yeah, but when you're asking for a deficiency, you're asking for both. So give me the security and pay me the rest of the debt under the note.
But here's the great counter to that. What happens if they're made whole out of the security? It becomes it reverts back to not an action to collect the debt? That can't be.
Well, that's what I was trying to get with Mr. Stopa. The deficiency action sort of floats around there until you get the foreclosure, you sell the property, and the title's issued.
Yeah, but I think what he's saying is listen, and again, I haven't decided. I truly am on the fence about this, so I'll play devil's advocate.
I've got some good points for you then.
Yeah, there you go. Okay. Try to push me off one way or the other. This is all about an effort at debt collection. And Mr. Stopa is saying this is a condition precedent to you initiating an effort at debt collection. And that if you file a complaint that says, you know, give me a deficiency, whether you're ultimately entitled to the deficiency or not, you have initiated an effort at debt collection, and that you should have been dismissed because you hadn't complied with the condition precedent. That
Sure.
seems to be.
Sure, 2 points. We have 11th Circuit case law, the Warren case, although it's not published, but none of the federal cases are binding. They're all for guidance. We have the Warren opinion, we have the Reese and Burster opinions, and then we have the most recently the Duravat opinion, which puts it all in line. It says, no, we're not overruling Warren. We couldn't overrule Warren. Warren's never been revisited en banc. And what Warren says is that the enforcement of a security interest is not debt collection. And then when you take that concept and you put it into Florida foreclosure law, I don't think that his interpretation of the statute can apply, because Florida defines foreclosure as an equitable proceeding. Case law defines the deficiency proceeding as merely ancillary to that equitable proceeding. So you have 11th Circuit jurisprudence saying that foreclosure, enforcement of a security instrument, is not, because it's an equity, is not enforcement of a security interest. And then you have Florida foreclosure law saying that it's all part of that equitable proceeding. And if I could specifically talk to this case, because something's very important about this case. Appellants urge this court to issue an opinion requiring the appellee to provide notice of an assignment that doesn't exist and is not required by Florida foreclosure law to exist. Consider this since you're on the fence. What happens when plaintiff is a holder of a note but is not an assignee of the right to bill and collect the debt? Happens all the time. Happened in this case. We have a plaintiff, possession of a blank endorsed promissory note. NationStar, the servicing company, has the right to bill and collect the debt. How could they ever provide that notice? They can't. He wants you to say that we need to produce something that doesn't exist under a standard that doesn't apply. According to his argument, the holder of a negotiable instrument cannot foreclose the mortgage unless the holder is also an assignee of the right to bill and collect the debt. Remember, not just the debt, the right to bill and collect the debt. That's what the statute specifically says. It's narrow. But controlling law provides the exact opposite of the positions espoused by the appellant. You do not need to be an assignee of the right to bill and collect a debt to be able to foreclose a mortgage if you are the holder of a negotiable instrument or a non-holder in possession with the rights of the holder. Now, if you don't need an assignment to enforce a security instrument, then how could giving notice of the assignment be a condition precedent to foreclose the same security interest? Now, that's why the 11th Circuit has never held a civil complaint to foreclose a security interest in real property is an action to collect the debt, and no Florida court has held that either. Warren establishes, as we discussed, and it's never been overruled, and it couldn't be because, like I said, the issue's never been revisited en banc. And Reese and Burster simply established that the party's actions, other than the filing of a lawsuit, such as pre-suit demands for payment, can still be subject to liability under the FDCPA, even though the debt's secured. That's consistent with foreclosure law. There's no problem there. The 11th Circuit reaffirmed Warren when it issues its opinion in Donovan, holding that the publishing of notices of sale and foreclosure proceeding is not a debt collection activity. And Donovan specifically stated that it didn't overrule Warren. Appellants attempt to distinguish this clear case law as unmeritorious and really amounts to material misrepresentations of existing cases to the court. The cases simply do not support appellants' warped interpretations. If you read the cases, they don't say what he says they say. The 11th Circuit has never held that the narrow sacrosanct act of filing a civil complaint for the equitable foreclosure of a security interest in real property is an action to collect the debt. And this court's opinion in Gann didn't hold otherwise. Judge Norcutt, you were on that panel. Gann involved pre-suit communications demanding payment of the debt, and the court found the letters could be construed as an attempt to collect the debt. That didn't deal with the filing of a foreclosure, seeking the equitable remedy of foreclosure. Now, I admit...
How about the Frere case? And I agree, because Gantt, I agree. I know Mr. Stopa is reading it perhaps more broadly than that, but talk about the Frere case, F-R-E-I-R-E versus Aldridge.
Sure, and that's actually what I was just about to get to, and I could group Frere with actually a couple other cases. So I admit that there are a minority of federal circuits who disagree with the 11th Circuit, no doubt, and they've been cited in the briefs. And there have been a couple of federal district court opinions issued in the last couple of years, which are also inconsistent with 11th Circuit jurisprudence, Frere being one of them. Now remember, these cases, including Frere, probably had a misunderstanding of the scope in Reese and Burster, and I don't want to, I respect all of those judges, but if you look at the court's opinion in Donovan, they cleared that up. my understanding is the consensus was we saw these cases coming out of the district courts of appeal. They seemed to be going astray from Warren, but Warren was never overruled. And then you have the court in Dunavant putting it all back in line and saying, no, no, no. The filing of a foreclosure complaint is not a enforcement of or an action to collect the debt. Now, these courts, including Ferrier, were relying on Reese to hold that the filing of foreclosure is an action to collect the debt, but Reese, like I said, couldn't overrule Warren, which explicitly found that the filing of a foreclosure lawsuit to foreclose a mortgage is not debt collection. And a reading of Reese and Burster on the face showed that they didn't overrule this holding in Warren. And importantly, none of these cases address 559715. None of them do. The only case in existence to address 559715 and whether it's a condition precedent to a foreclosure at the federal level is the recent opinion on July 2nd, 2015 in Summerlin. That was issued by Judge Robin Rosenberg. She is former 15th Judicial Circuit Chief Judge of the Foreclosure Division. I've had the pleasure of arguing in front of her many times. She is a very good foreclosure judge, and she adjudicated this issue directly in favor of the appellee, and that's the most recent case to come out on this issue. And I want to jump back in time a little bit to Trent, and I acknowledge that Trent is also a federal district court case, but Trent is so important and is so consistent with the principles that the appellee and I have put forth today. Trent said the following. Trent stated that a mortgage foreclosure action does not qualify as debt collection under the FDCPA. Now here's where we get to the real meat of the issue. Trent stated that the contrary ruling would create serious constitutional concerns for access to courts to enforce a security instrument. That's exactly what I raised the question in the beginning of this oral argument. What happens when you're the holder of a note, but you did not receive assignment of the right to bill and collect it? Your servicing company did, and they bought those servicing rights, and they're the ones who have the right to bill and collect the debt. All you are is the holder of a promissory note under 673-3011, and Florida case law says you get to foreclose with possession of that blank endorsed note, and you don't need any assignment whatsoever. If we adopt an opinion consistent with the appellant's position, we will be doing exactly what the Trent court 9 years ago cautioned everybody what would happen. It would create serious constitutional concerns for access to courts to enforce a security instrument. And the appellant's position would run afoul of binding Florida law that a holder of a note has standing to foreclose when not requiring assignment of mortgage to foreclose. And I want to point something else out too. Trent was affirmed by the 11th Circuit Court of Appeal. If they had a problem with that legal position, they could have taken it up then, and they didn't. And it was Trent was also cited favorably when the court issued its unpublished opinion in Warren, the 11th Circuit. If there was a problem with Trent, we would know about it by now because the 11th Circuit has had a chance twice to correct it, and they didn't. Trent is good law, and that is the salient issue for all of these issues. And the legal position urged by the appellants would hamper holders of promissory notes' abilities and access to courts.
Well, you go back to the old days and you take out the 30-year mortgage and the same bank holds it forever.
That's not the world we live in, unfortunately, Your Honor. Something else I'd like to point out is interesting. If you receive a discharge of your indebtedness pursuant to the bankruptcy code, you know what? Your creditor is not allowed to take any action to collect that debt against you, and if they do, they get in big trouble. But you know what that creditor is allowed to do? Enforce its security interest, because the bankruptcy code finds that is not an action to collect the debt. Isn't that interesting? That's from the United States Congress.
Does it get a deficiency?
No. If the court is concerned about the protection of consumers, I would point to the Real Estate Settlement Procedure Act because it provides better protection than this statute does. The Real Estate Settlement Procedure Act requires, at the time that the right to bill and collect that debt is transferred from one company to another, they have to give notice to the consumer that that right to bill and collect that debt is being transferred. Not 30 days before an action to collect the debt, but within a certain, I think it's 60-day window around the time of the transfer. That could occur years before any action to collect the debt. RESPA is more protective of consumers, and it should assuage any concerns that the court has about consumers being railroaded or whatever it may be into a court case without being provided a non-existent statutory condition precedent. talk a little bit more about the facts of this case. The record reflects the plaintiff was the holder of the note. The record also reflects there was never an assignment of the debt to plaintiff. Now remember, the statute is the right to bill and collect. But even in this case, we don't even have an assignment of debt. Appellant's counsel argued that the assignment of mortgage was insufficient to convey the debt pursuant to controlling case law, and the court found that he was just a holder of a blank endorsed note and didn't use the assignment. So in this case, we don't have an assignment of the right to bill and collect the debt, and we don't even have an assignment of debt, yet he wants us to prove that we sent those things. He's asking for the impossible under an inapplicable statutory section. Just talk really briefly about some of the trial court. There's no actually evidence before the court in this case to support the claims that 41 local trial court judges agree with appellant's position, and I don't think that he's misrepresenting that to the court. Just point out that that's not in the record. There's no trial court. It's anecdotal.
And just to let you know, to put your mind at ease, this is all well and good, but obviously that's not really binding when we do our review.
It is not binding, and I think that we had mentioned this earlier, but in my experience, the vast majority of judges across the state do not agree with appellant's position. I've litigated foreclosure and lien priority and lien issues from Milton and the Panhandle all the way down to Miami, and I've never lost on this argument, ever. He has. Appellant's counsel has. That's why we're here today. I've never lost in this argument because it's the correct legal argument. Appellant cannot cite a single 11th Circuit opinion that actually supports his position. An appellant cannot cite a single Florida case that actually supports his position. And this is because the 11th Circuit jurisprudence and Florida law provide that an action seeking the equitable remedy of foreclosure in a Florida court is not an action to collect a debt. The most recent federal district court case directly on point with whether 559-715 is a condition precedent to foreclosure holds it's not, and that's from a foreclosure judge. She was chief of the 15th Judicial Circuit Foreclosure Division, Judge Robin Rosenberg, great judge. Briefly and simply, the appellant urges this court to issue an order or an opinion requiring the plaintiff to produce an assignment that does not exist pursuant to a standard that does not apply. Today, the court should affirm the final judgment of foreclosure because the narrow, sacrosanct act of filing a civil complaint for the equitable foreclosure of a security interest in real property is not an action to collect the debt. We respectfully request the court affirm the trial court's opinion.
Thank you, Mr.
Thank you.
Schwartz.
May it please the court. There were a lot of arguments made by my opponent that were not briefed and were not in the record. I trust that the court will overlook all those issues. Your Honors, there can be no serious doubt that the ultimate purpose of foreclosure is the payment of money. That's the Sixth Circuit Federal reading from the decision. This case started with a letter demanding money, and then a complaint that demanded an amount of money, and a final judgment that required payment of a specific amount of money, and only if that money was not paid within the statutory redemption period would there be a foreclosure sale. Everything about this was about the payment of money. The case law in the federal appellate courts is very clear in that regard. Now, my opponent says there was no assignment and talked about the right to bill and collect. Your Honors, the original lender was Countrywide Home Loans, Inc. The plaintiff was U.S. Bank as trustee of a securitized trust. There was an assignment of mortgage introduced into evidence showing them to be the assignee. They're the assignee under the statute as a matter of law, so the statute clearly applies. My opponent is trying to argue there was no...
They just got an assignment of the mortgage? That's what I think I'm hearing.
Assignment of the note and mortgage. The assignment of mortgage. The assignment of mortgage introduced into evidence, at trial, conveyed the note and mortgage. They're the assignee under the statute. Now, so my opponent talked about, well, there is no notice, a non-existent notice. That's kind of the point. The statute requires notice of assignment to be given 30 days beforehand. He's trying to argue some, pragmatic matter of it doesn't exist. First, there was no record evidence of that. The only record evidence was that they didn't have it there at all as part of their prima facie case. But this argument about right to bill and collect, I deal with that issue a lot, okay? And a lot of times, and it sort of corresponds with the RESPA argument that he made. A lot of times what the plaintiffs try to do in these cases is introduce into evidence a notice of change, what I call a notice of change of servicer. That's what it's commonly called, and he even alluded to it. Section 6 of RESPA, the Real Estate Settlement Procedures Act, requires that when there's a change of servicer, you have to give written notice of the change of the servicer to the consumer. That is a totally different statute and a totally different issue than this issue. But now here, he acknowledges that notice that it exists, but they didn't introduce it into evidence, right? So we're not here arguing whether a notice of change of servicer was sufficient to comply with the notice of assignment of the debt under 559715. That's a totally different argument because they didn't introduce that into evidence.
You wouldn't go so far as to say that when there's an assignment to a new servicer, that's the person that has the right to bill and collect?
I think it depends.
Okay.
I've had circuit judges go both ways on whether a notice of change of servicer is what is required by 559715. I tend to think that it doesn't. It sometimes could, depending on what that notice specifically provides. But on the facts of this case, there is no notice of change of servicer. They introduced nothing at all into evidence. So to the extent that he's arguing, well, that the statute 559715 only contemplates an assignment of the right to bill and collect, they did not give any notice of the assignment of the right to bill and collect. So here, even if you thought that was sufficient, there was no notice here at all. So they introduced nothing to prove their prima facie case at all. Now, I do think it's clear that they are different issues because the RESPA, and if you look at those notices will usually actually specifically refer to Section 6 of RESPA. They'll say in the notice, Section 6 of the Real Estate Settlement Procedures Act requires that we give you written notice of the change of servicer. And that's what we're giving you this notice pursuant to. I see them all the time. I don't know if your honors have ever seen one. It happens all the time. That doesn't exist here. So they clearly don't comply with the statutory obligation by this notice of change of servicer, which they didn't even introduce. So, and that issue of whether that is sufficient to comply with the statute wasn't even briefed because it's a non-existent fact pattern. So they clearly can't affirm based on any of those arguments at all. Now, just as I promised your honors, they have no opposing case, contrary to Hallstrom, the U.S. Supreme Court case, or the Florida Supreme Court case, or Neat and Freeney, all those cases that where a statute requires a notice a certain number of days before action taken. You didn't hear any arguments about that at all. No opposing cases on that at all. That's why, to me, it has to be a conditioned precedent. The only arguments that you heard was, well, this is a really good judge. I mean, it's still one trial judge who didn't make any analysis at all on it, and that's not a criticism. It just is. For instance, another case they cite two at the same time, Gillis, that decision, that was a pro se homeowner who did not even file a response to the bank's motion. Well, on a close call where the consumer doesn't even file a memo in opposition, is it really terribly surprising that the appellate court rules in favor of the lender? I don't think so. So to me, that is of really no value at all. Summerlin is really of no value at all because it doesn't have any analysis. To me, the cases that are just clearly on, and Donovan, my opponent doesn't even try to explain how, or just get around the fact that that was a notice of foreclosure sale in a non-judicial foreclosure state. He doesn't try to get around Maynard, the 10th Circuit decision that I cited that distinguishes judicial foreclosure actions are actions to collect debt under the FDCPA. Non-judicial foreclosure sometimes aren't. We're obviously dealing with a judicial foreclosure. Didn't even have any argument on that. That's their lead case, Donovan, on a non-judicial.
Mr. Stepper, you need to wrap up. Your time is expired.
So, thank you, Your Honors. For all these reasons and for the reasons in the briefs, I submit that this court should reverse, should issue a written opinion so that the lower courts can have clarity showing that 559715 applies in the mortgage foreclosure context, particularly when you have a letter demanding money and a request for deficiency, and should remand with instructions to involuntarily dismiss without prejudice. Thank you very much.
Thank you
very
both.
much.